arbitration and its career prospects. So the contents of this webinar will be: one, disputes in construction, a major area. That's why we get into arbitration. Then we will see what is arbitration. We'll move on to why arbitrate a dispute and why we do not litigate it. Then we go in carriers in claims and contracts. Then a carrier will have a look at the carrier life cycle, means how a fresh engineer can plan his career so that he can come into claims and contracts and then into arbitration. So basically coming on to disputes in construction. So a dispute, disputes are reality of modern life. See this Moffat, Michael, and Robert C. Gordon in the Handbook of Dispute Resolution. They have defined disputes very beautifully. They have said that disputes are a reality of modern life. Each of us has our own perspectives, our own interests, our own resources, our own aspirations, and our own fears. So it is no wonder that as we run into each other, we sometimes find ourselves in disagreement about what has happened or about what ought to happen. So this is the basic definition of a dispute. Basically, it's a general definition.
Sir, sorry to interrupt. We can't see you, sir. The video is not visible.
Just a minute, then I'll just have to stop sharing and then I'll have to on my video, is it? Because I cannot see. Okay, just here.
You can just click the video button, sir.
Yeah, I got it now. Can you see me?
Yes, sir. Yes, sir. Yes, sir. Thank you, sir. Okay.
So we just discussed about disputes. Then in construction, basically in construction projects, these projects are very complex. They are of long durations and they are of high value and they're unique. Every construction project is unique. You don't have a duplicate project except maybe for some petrol stations and all. But usually a construction project is a unique project. So, and since it's very complex and it's huge, so all details of a construction project cannot be crammed into a single contract and a tender detail and all. Some details have to be worked out later on. So this is one of the things which leads to disputes. And since there are a large number of parties involved in a construction contract, it's the contractor, it is the owner of the project, and then you have the consultants, basically the engineer, and then you have a lot of third parties involved, like you'll have vendors, you'll have subcontractors, you have suppliers. So this is this makes it a breeding ground for disputes. So now Arcadis is a global consultant, and they have published a construction dispute report. And what they say is in 2019, the overall volume of disputes in construction sector in major regions like North America, UK, the European continent, Middle East, in these areas, it was about only the value of the dispute was $33 million, American dollars. And the average time to resolve these disputes was 17 months. Now, $33 million is only for these four regions, what I talked about. But if we take other major regions like Africa, like India, and other parts of the world, certainly the dispute figure is going to be in triple figures. It's going above 100 million or so. Here I am sharing you the data of what the Arcadis Global Construction Dispute Report is saying. You can see the graphs and how they move from 2011 to 2018. So the dispute is reducing. But this is the data of the dispute which is going to arbitration, or which is going to maybe litigation also. But disputes, every project will certainly have some sort of a dispute in which dispute resolution has to be taken up. So this graph does not portray the exact the quantum of disputes. There are disputes which are reached amicably, which are not reported. There are disputes which are settled, which are not reported. So this graph does not include that, but it is a general picture of disputes in construction contracts in these four regions. What you see there, it's North America, UK, continental Europe, and Middle East. So you can go through. So in 2011 we are about 100 million, above 100 million. 2012 it reduced. 2019 it has come down to 33 million. 2020, what I am seeing is, because of the corona crisis, certainly we are going to have disputes which may be quite high, and the amount, the average value of dispute is certainly going to increase, because the corona crisis has gotten unprecedented. It's really unprecedented. It stopped works. It has stopped many construction sites. It has affected the supply chain. So certainly there are going to be disputes. And in 2020, what I anticipate, it's going to near about $100 million in disputes. So now we come to what is arbitration. Arbitration basically is a procedure in which disputes among contracting parties are resolved in private based on voluntary agreement of parties to arbitrate. Now, to resolve a dispute, you can have a lot of procedures. There is the mediation, there is amicable settlement, and then there is med-arb, and there's so many other dispute resolution procedures. But arbitration, why we arbitrate is, arbitration, the award of an arbitration is final and binding. And usually courts do not interfere in an award of an arbitration until an that it is unjust, can prove that it is unjust, or there is a question of law on that in the award. So now, discussing arbitration, an arbitration can be commenced by either of the parties in case a dispute arises. So arbitration can be commenced by giving a notice of arbitration to the other party and appointing an arbitrator. And basically, an arbitration can be commenced if you have an arbitration agreement. And parties can agree for arbitration. If the arbitration agreement is not contained in the contract, parties can agree to arbitrate later on also. They can make an agreement. And when arbitration is commencing is an important date, because it has a lot of bearing on the later parts of arbitration. That's a further discussion, which I don't think so, because it will be very long. So I'll just keep it up to there. So basically, arbitration agreement will say what disputes are going to be arbitrated, how many. It can also say that, okay, this so many. Can it be an ad hoc arbitration, or it has to be an institutional arbitration? I'll come to that. What is an ad hoc and what is an institutional arbitration, and what rules of arbitration can be used. And as you see, the current scenario all over the world is, all the countries all over the world have an arbitration law in place. So there is a separate law in each country. In India also we have an arbitration law. England we have an arbitration law. Scotland we have an arbitration law. Middle East we have an arbitration law. Every country of the Middle East has its own arbitration law. The arbitration procedures are carried out as per those arbitration laws. The UNCITRAL model law on international commercial arbitration was prepared by UNCITRAL, that is United Nations Commission on International Trade, and it was adopted on the 21st of June. This UNCITRAL model law was a template law in which UNCITRAL suggested to all the countries, see that this is a model law, you can adopt it and you can make changes to it as per your legislation. So countries all over the world adopted some form of it. They adopted it in toto without any changes. And some countries, they made some changes like Egypt, Oman, India. They have made some changes to that according to their legislation. So basically what I want to say here is arbitration is governed by law. And the main thing is it is binding to on the parties. Now we come to what is an ad hoc arbitration and what is an institutional arbitration. Basically, an ad hoc arbitration can be any arbitration. The owner and the contractor can agree. Basically, it can be the owner, the contractor, or the contractor or the subcontractor. It can be parties to a contract. They can agree to carry out arbitration as per institutional rules. Institutions like Chartered Institute of Arbitrators, the international that ICC, and we have American Court of Arbitration, if I remember that correctly. These institutions, what they do is they administer an arbitration. So parties can approach these institutes. These institutes give the arbitrators, they suggest the arbitrators, and they charge the fees, and they administer the arbitration. So arbitration is administered properly. Chances of the award being annulled or not enforced are less. Whereas an ad hoc arbitration is two parties can agree, they can just pick up an arbitrator, select an arbitrator, and start their arbitration as per, and the arbitration will be governed by the arbitration rules which they agree to or by the arbitration law of the country. The continuation of arbitration, as I said, arbitration award is binding on the parties. There are very few instances in which an award can be challenged in a court. It is conducted, arbitration is conducted nearly same procedures as a court, but with so many formalities. A court has many formalities, where an arbitration can be conducted in private and the formalities are less. The number of arbitrators can be one, can be three, or can be five. It can be two also. You can have two arbitrators, but the problem is if there is a deadlock, it's very difficult to solve. Because one arbitrator will agree on something and the other will agree on something, then you have a deadlock. So usually it is one or it is three. So when there is a deadlock, the third arbitrator, who will be the presiding arbitrator, decides on what is the award. The arbitrator in the panel has the power to award damages, and the power of the arbitrator, if it is one arbitrator or three or five, it's called the arbitral panel. Arbitral panel has the power to award damages for any breach of contract which they find. They can award restraining orders. They can subpoena a witness. That is, if a party, if the arbitral panel thinks that a witness is wanted, that witness can be brought in the proceedings, in the hearing, without his will, through the support of the court. So in arbitration, all the countries have a policy to support arbitration. Usually courts will not interfere into an arbitration, and the policy of each country is that least interference in arbitration. And also, if commercial parties go into court to directly litigate the dispute, most of the times it is the courts will refuse and they will say, first you arbitrate, and despite there has been cases in which the courts have refused litigation, and they have asked the parties to arbitrate the case first and then come back and litigate if required. Now we come to why arbitrate? Why not litigate? You have litigation, you have courts, you have so many levels of the courts, you know. You have the lower courts, then the high court, and then you have the Supreme Court, and you have the Court of Appeal. So basically, the question is why we need to arbitrate? Why not go directly to the courts? First thing in arbitration is the award is final and it is binding like the award of courts. Second thing is the most important or the biggest advantage of arbitration is if an arbitration award is made in one country, it can be enforced into the arbitration award can be enforced in the other country. If it is a signatory of the New York Conventions on enforcement of arbitration awards, New York Conventions is a treaty which nearly all the countries of the world have signed. This is a treaty which relates to the enforcement of arbitration awards of other countries in their country. Now, the advantage of this is in the current times, we have a lot of international contracts. You will have, let us say, you have a contract in Middle East somewhere, you'll have some contractors from Brazil coming in, you'll have contractors from India coming in, and you'll have contractors from so many countries coming in. Some disturbance. Now, a contractor coming in from other countries will have origin in other country. Like if a contractor is from Brazil, his assets will be in Brazil, but he will be working, let us say, in Muscat, okay, in Oman or in India. He is working there, but his assets are in Brazil. Now, if he defaults and there is a breach of contract, this contractor can just simply, whatever small assets he has in India is working or in Muscat, he can just sell them off and run away. The party who's the injured party, who's the employer or the owner, or it can be the other way around, if you go to a court, you will get an award. You will get a judgment. That judgment is very difficult to get it enforced in other countries. So what you will have is just a simple piece of paper, because you may have that, okay, so many millions dollars of damages is awarded to you. But from where will you get those damages? The contractor has already gone. He was from Brazil and his assets are there. You cannot liquidate his assets. Whatever assets are there in Muscat or Oman, that's all what you have. And that's not sufficient. But in arbitration, what happens is, if the arbitration award is given, the party who gets the arbitration award in his favor can go directly to Brazil, submit the arbitration award in the courts, and ask the court to enforce it. As per the New York Conventions, if Brazil is the signatory of New York Conventions, which it is, it will enforce the award, and that contractor will have to pay the damages to this party. So this is one of the major advantages of arbitration. The third advantage, what I see, which is very big advantage, it's significant, because commercial parties basically would not like to arbitrate or resolve the disputes. They don't like to make the disputes public. So they avoid going to court. They like the disputes to be resolved silently, and also they don't like to lose money. So most of the cases they avoid going to court. Arbitration is private and confidential. That is why you will not find arbitration awards, very many of the arbitration awards in libraries or in journals. You can find judgments. Judgment of courts you can find in there are so many sites. who give you the judgment of courts, and there are so many libraries who keep them. On the internet, you can find them. But arbitration awards are not like that. They are very private and they are very confidential. Two parties can confidentially and privately arbitrate and finish, get the award, settle the dispute, and move on without any much publicity, which commercial parties really don't like it. Then we have that arbitration. Basically, arbitration was made and was propagated because it consumes less time and it is cheaper than litigation. Although it may not be true in the current times, but still, if the parties are they really want to expedite an arbitration, they can do it. But sometimes it happens that one party would like to arbitrate and the other party would be running away from the arbitration. So the other advantage of arbitration that it's less time, cheaper, and it's confidential. Its awards can be enforced anywhere, and the awards are final and binding. Okay, that's in arbitration. It was a very brief introduction because it's a very huge topic. We have books of many volumes on arbitration, and I cannot cover it, and I don't think so. People will be very much interested in the details of it. So I have not covered it very much, but I do welcome questions. And if required, we can have another webinar which can be a detailed discussion of arbitration. Now I come to carrier in claims and contracts. Now, arbitration is in itself, it has several branches. An arbitration or an arbitrator will require experts to assist in his uh, determination or in deciding the dispute itself. He requires planning and scheduling of experts. He will require quantum claims experts. So we come to how you can plan your career in planning and scheduling contracts and other such fields. So basically, planning and scheduling, a forensic delay analyst is a planner. Basically, he comes up from planning and he gets into a detailed planning, and he's the one who finds out exactly what has happened in a project after forensically studying all the programs and the scheduling which the contractor has made. What he can analyze the delays and the responsibility. He can decide the responsibility of the delays and he give his expert opinion on that. It's a very lucrative career and it's very rewarding also. I don't know what is in India, but it is very rewarding internationally. So what you need to be a forensic planner is, the first thing the planners should learn are the standard practices for preparing construction schedules. And now, usually, what happens is when a graduate engineer graduates from the college, what's his first preference is to go and start working. Well, that is good, that's fine. But when you work, while working, you have to know what are the good practices and standard practices which are acceptable internationally. Now, regarding to planners, documents like AACE 29R03 and SCL protocol, that is the Society of Construction Law Protocol Revision 2, this should be studied in detail. I know immediately after graduating and going to the field, you will not be able to understand this. But if you're taking a course of Primavera or you're taking a course of MSP, which I highly recommend you because it does not, you can always work and you can do this also parallelly. You have so many online classes and nowadays the education sector is booming. You can utilize your time in studying these documents. These are standard documents, and when most of the planners, where they go wrong is they don't follow the practices recommended in these documents. These are standard, internationally accepted practices, and they are very good practice. And every planner should understand and should prepare his plan as per these practices. It is always be acclaimed and he'll always be recognized, because there are very little planners who do this, and there are very little people who know about this. I just want to share my knowledge of this to you all, because when we graduated, we didn't have all this. So I just thought, okay, let me share this knowledge with everybody so that everybody is can adapt to it. And a good knowledge of software and its working is also essential. Now, to become a forensic delay analyst, you will have to have some experience of planning and scheduling. And then only you can become, because you cannot just go and start a career of forensic delay analyst immediately after graduation or immediately after you have started your planning and scheduling. You need to have some experience. Now, coming to contracts, this is also a very interesting career. People who are interested in quantity survey can go into this. It's a career which is very rewarding internationally. What it needs is you should have good knowledge of contracts and its clauses. You should aspire to gain membership of professional bodies like RICS, AAC. Gaining membership of professional bodies gives you an edge above the others. Everybody should know that. It gives you an edge. RICS, Royal Institute of Surveyors, Chartered Surveyors, they have a student membership, and my advice will be all students should take it. It takes some, you need to pay something, but it's worth it. And then you can move on from student membership to associate member, from associate members to member, from member, then you can go to fellow. So it's really rewarding. The material they provide you is very good. It's up to date. It gives you the knowledge of what's happening around you. And second, the third thing what I want to say is anybody in contracts should understand pre and post contract procedures. There are procedures which is pre-contract, that is before a contract starts, that is the designing, the tendering, and all those things. And then there is the post-contract procedures, that is the execution part. People should understand this, and they should gain knowledge on drafting of small contracts. See, big contracts, the main contract, we have standard forms of contract like FIDIC, NEC, JCT. There are so many standard forms which we use nowadays. But small contracts, like if you want to give a subcontract to somebody in your company, you should know what should be there. So this, you should learn you should strive to learn this. And the career here is the start of your career going into claims. After this, the next step will be you go into claims. Basically, what is needed to understand claims is a very good knowledge of quantity survey, a very good knowledge of construction law. You can gain knowledge of construction law by getting admitted in any one of the universities. There are so many in England, there are so many in Scotland. You have some in Europe also. You can just enter that. They're a bit expensive, yes, but they provide scholarships and other things. You should. They give you a lot of knowledge, and it's worth it. And you'll be recognized, and certainly it's a boost to your career. Again, I tell you, membership of professional bodies like RICS, Chartered Institute of Arbitrators, these things students should strive for. Now, what I see is a student after graduating, what he does is initially he'll start to look for a job. That's good. As I said, it's good. But you should also think of your career, what's going to come ahead. You have all those, you are enthusiastic and you have all those, you have the energy and you want to start a job. Certainly, it's good, you should do it to gain experience, but parallelly, membership and gaining knowledge should not stop. You should always strive to learn. If you do that, you'll always be successful. You'll always be respected. Now, to become a claims consultant, you should have a knowledge of contracts. Experience should be above 10 years. Because then only you can, it's not only consultant. It's not only, maybe you have so many companies which require claims experts who can prepare their claims. There is shortage of guys who can prepare claims. See, you have so many courses which you can take. It's all over the internet. You can go and search. AAC provides courses and they provide certification for QS, for certified, what do you say, delay analyst, and so many other things are there. It costs a bit, it does cost something, but yes, but it is worth it. You will learn. The first thing is you will learn. You will learn from there. And it's not that only you go to the site, see the execution. Okay, now, okay, so this is the shuttering, this is this. Okay, that's common, that everybody knows it. And you just need to have some experience, that's all. Later on, it's your knowledge, it's your experience that counts. So coming on to arbitration. Now, if to become an arbitrator, the most interesting part of becoming an arbitrator is it doesn't need a qualification. There is no qualification needed for becoming an arbitrator. Yes, but you need to have, when you are going to write an award, you should know what is the requirement of the award so that it is enforceable. Yeah, there are some requirements of an award as per the New York Conventions, as per the local laws. So there will be some requirements. So you should know what are those requirements. You should know when you are deciding on something, you should know the law and the construction law also. Experience of, if you are in this field for 10 years, certainly you can become an arbitrator. Now, to gain arbitration experience is you get into claims, you get into delays, slowly you start assisting in arbitration, and then you can become an arbitrator yourself. Arbitration is a very rewarding career, and it has a lot of scope. And I can tell you, it is rewarding financially, and also it's very respected career. I will just go through a career life cycle. I think I've taken much of the time. So I've just prepared some cycle according to my knowledge. I'm not a career consultant, but what I see and what I have gained from experience, I have prepared this, and I think all of you will find it useful. So now the first stage, what I see is a graduate. You graduate from college with good scores. You should learn software like Primavera, acquire expertise in Excel. And I am an admirer of Excel. I really love that software. You can do really anything in that. You can make claims, you can design, you can program, you can do anything in that. It's really a good software. And people should learn, all engineers should learn, should be experts in Excel. That's my recommendation and my advice. And the second, the last thing is the student membership of professional bodies. You should start taking those. Those are really good. These things are going to benefit you. And whenever you put that on your CV, whoever sees it certainly will know you are an edge above the others. The second stage comes, you should gain at least about 2 years of field experience. That is, I will not say when you graduate, you should go to the field. Maybe you should be working with planning, but you should be going to the field. You should learn. You should have hands-on experience. Something wrong somewhere. Okay. So, see, this helps you later on when you enter into planning, because when you have an experience, you can plan very nicely. You can you can plan practically. Whatever you plan, your plans and programs will be practical. and people will understand and they will respect your plans. Third stage will be you enter into a QS department, a planning and QS department, adapt good construction practices, as I told you, AAC 29R03 and SCL protocol. Those are the things which you need to see, which you need to learn and adopt. Then you can take courses, certifications, and move on to become a delay analyst or a claims manager or a contracts manager. Once you do this, you enter into arbitration. You should take membership like RICS, CIRB, and you have, I'm forgetting that MICOB, that the Chartered Institute of Buildings, MICOB. That is also a very good certification if you can take that. And then the final stage is you become an arbitrator or a forensic delay analyst or a quantum claim expert. So a forensic delay analyst or a quantum claim expert are experts who assist the arbitrator. They are the part of the team. You may not be, you can work independently, or you can work with a company, you can work within your own company, you can work as freelance. It's really rewarding financially. And I think I'll end here. I've taken much of your time. Now, I would ask if anybody would have any questions, please. Anybody would like to ask questions?
Questions in the chat box, sir.
Just a minute. Okay.
There is some questions from Ganesh Babu.
Okay. In India, arbitrators can how much they can earn in a month. That depends. Basically, in one arbitration, I was taking about 1 lakh per sitting. So it's a huge amount of money, but the problem is you don't have arbitration. It's not continuous. Arbitration, you can earn a lot of money. Arbitration is a process. It takes up to 1 year. So for everything, like you'll have initial payment, initial fees for an arbitration when you start the process. That is when you study their contract, you'll ask for some fees, maybe about 50,000, 70,000. Things you'll have the study the claims, the counterclaims. So in an arbitration, basically in one arbitration, an arbitrator can make, I think, up to 5 to 7 lakhs, but that takes up to 1 year, you can say. So if you have 2 or 3 arbitrations running, see, money in arbitration can depend on the type of arbitration. If it's high value arbitration, you're going to have a lot of money there. Okay, there is something else from Ganesh Babu, mediator arbitrator. Mediator, I don't know much about mediation because I have not been, but it's not that much rewarding. Mediation is something between the parties which they decide to mediate, but it's not binding. And nowadays, mediation it's more of a what you say amicable settlement. So if both parties are agreed to it, they can go for mediation. And fees about the carriers and what is it, money in mediation. I'm not into mediation, so I think I'll not be able to tell, but it'll be a little bit less than arbitration. Anything else? Anybody?
Participants, if you have any question, you can unmute your mic and you can ask the questions.
Okay. Started getting thank yous. So I think that's it. Rohini?
Sir,
Boring. It's very interesting, sir. Not boring. They are saying thank you because
I hope
they
so.
want to say thank you.
So I just would like to say something. I'll be conducting webinars. That's now I've conducted this one, but I'll be conducting my own webinars. If anybody wants to join in them, I'll be sending a link to you, Rohini, and so you can ask somebody to join. And if required, we can have another session on some say delay analyst, a more detailed session on any of these, if required, if you are interested.
yes, sir, sure,
Okay,
sir.
sir.
Sure, sir.
Okay, that's the meeting. Thank you all. Thank you for listening. It was a great time with you. It was my
Thank you,
honor
sir.
and my great pleasure.
Thank you, sir. Now I
Thank you.
request just a
Basant, sir.
okay. Now I request Dr. Yoganathan, Department of Civil Engineering, to give an vote of thanks.
Thank you, sir. Thank you for giving me chance to propose vote of thanks. So thank you, Engineer Mohammad Akhtar Beg, sir, for giving a wonderful lecture on arbitration. So these are the very rare opportunities we are getting attending such type of webinar program. So very thankful to you. On behalf of all the participants, I once again thank Engineer Mohammad Akhtar, sir, on behalf of Civil Engineering Department. And I thank all the participants from various institutions and organizations like Association of Consulting Civil Engineers, Association of Madurai Civil Engineers, and all other group of institutions. I thank all, one and all. Thank you, sir. Thank you.
Thank you, dear. Wonderful. It was my honor.
Sir, Beg, sir. Thank you, sir.
Thank you. Thank you, sir.
Sir, thank you, sir. Beck, sir, thank you for joining us in spite of your busy schedule, sir. Thank you.
No, not at all. It was my pleasure. It was my honor. I really honored.
Thank
Thank
you,
you.
sir.
Thank you so much. Have a nice day. Bye.
Bye, sir.
Bye.
Thank you, sir. Participants, you can submit your feedback form, which will be sent to your mail. Certificates will be issued based on your presence in the webinar. Be checked with the screenshots. So if your name is not in the screenshot, certificates will not be issued. Thank you.
Sir, Basant, sir, some
Yes, sir.
participants haven't registered, it seems. So they have given in the.
Oh, yeah, they can send their details. Those who are not registered but attended, they can send their details to the coordinator. We will send the certificate. So those participants who are not registered but they have attended, they can also receive the certificate